This is the 7th talk in a series brought to you by the Foyle Product Liability Sector Focus Team. My name is Gemma Pressman. I'm an Associate Solicitor at Waitmans LLP, and I specialise in product liability casualty claims. I hope you will have had the opportunity to listen to the last talk in our series, which was brought to you by Foyle's guest speaker, Nicola Fallowfield-Smith from Hawkins, who discussed material failures and forensic investigation. Today, I'm going to provide you with a basic introduction to product liability claims in the USA and the effects of social inflation. So for those who are perhaps unfamiliar with the operation of product liability law in the US, it's helpful to understand that it's a blend of state and federal laws and the common law. Most law is common law that has developed in each state. It is court-made law. So it's based on prior case law from the trial courts and the appellate courts. Some product liability law was first established in the common law and then adopted or modified by some state legislatures in state laws. In addition, some state legislatures first adopted product liability laws in their state despite the lack of case precedents on which to base their statutory law. There is generally no federal product liability common law. It's viewed as a matter for each state to establish, as it is local law that affects state residents and companies that sell into each state. So it is perhaps unsurprising that against this background, product liability claim outcomes can be fairly unpredictable across the country as a whole. The system is often described as unpredictable and perhaps a bit quirky. Procedurally, unlike in England and Wales, where each case will be determined by a judge, if a case is commenced in a state court, then the state court judge will preside over the case and will rule on evidentiary issues. But the parties may request a trial by jury or by the presiding judge. If the case is to be dealt with by a federal district court, then the parties may also request a trial by jury or a bench trial by the presiding judge. So, on what basis could you go about bringing a product liability claim in the US? There are many possible causes of action that may be alleged to recover damages caused by a product defect. The principal liability theories, which will be familiar to those of us with a knowledge of the system in England and Wales, include negligence, strict liability, and breach of warranty. The way the system has developed in the US is interesting. The original basis for proving a defect was something known as the consumer expectations test. So this test allowed a consumer to say the product was more dangerous than they expected when being used in an intended and reasonably foreseeable manner, and that this had caused their injury. However, this test was criticised as being too vague and not providing much guidance to manufacturers or to juries. So the risk utility test was developed in the 1970s, and that was adopted by many courts. In 1998, it was incorporated into the Restatement Third of Torts, Products Liability, which has been gradually adopted as the leading source for the description and development of product liability law. So under this risk utility test, there are various relatively clear factors that the jury can use to decide whether the product is defective. These factors allow the jury to weigh the risks in the product against the ability of the manufacturer to reduce the risks. The test is viewed as making it harder for plaintiffs to recover because the manufacturer can defend itself by saying that it made the product as safe as necessary or as possible. Therefore, even if the product was more dangerous than the plaintiff anticipated or realised, the manufacturer may prevail. The risk utility test, which originally applied to strict liability, is very close to negligence, as it allows a manufacturer's conduct or their fault to be considered. And as a result, in the states that have adopted the risk utility, there has arguably been a merging of the concepts of strict liability and of negligence. So today, the majority of states are using the risk utility test, and you might therefore be forgiven for reaching the conclusion that overall outlay in these actions would not be overwhelming. But the developments brought about by social inflation have seen the most significant of awards become increasingly routine. So, what is social inflation? There is actually no one standardized definition, But social inflation basically refers to steeply rising insurance rates due to social factors such as large jury awards and increasingly broad definitions of liability. With social inflation comes risk and economic consequences. Its risk is saliently different and novel from the traditional risks in insurance and influences multiple lines of business. It is by no means a new phenomenon, but it is certainly becoming more prevalent. Recent studies have shown that the number of verdicts and settlements exceeding $50 million has increased almost threefold in the last 10 years. The changing claims landscape is increasing balance sheet provisions and market stresses, and it is certainly not unusual today to see insurers defending $100 million plus professional liability claims. It's obvious that these developments will have a direct effect on insurance pricing. It's arguable that social inflation risk actually has a double kick effect on insurance. It increases the effective marginal cost to the insurer, since the policy has a higher probability of becoming nuclear, which is now commonly defined as jury awards and settlements which exceed $10 million. It also increases the amount of statutory reserves required to satisfy the risk-based capital requirement. Together, they evidence that higher social inflation risk translates into higher prices. The most obvious recent example comes as a result of the COVID-19 pandemic, where insurers are facing a deluge of lawsuits and legislative efforts to force payouts, primarily for business interruption. From the insurer's perspective, the risk of social inflation poses a fundamental challenge to the supply of insurance. In its very simplest form, the provision of insurance can be expressed as a mapping from an event to the point of payout. Importantly, the traditional assumption is that the mapping remains stable from the time of insurance underwriting to the time of actual payout by the insurer. Social inflation risk questions this assumption by introducing sizable uncertainty to the underwriting. It is generally acknowledged that medical costs and economic inflation are a large component of jury awards and insurance rates. Interestingly, the rise in nuclear awards actually outpaces the rate of inflation and increases in medical care costs, which are the traditional drivers on price. And as I have alluded to, cases of concern here are commonly within the medical sphere. Plaintiff legal teams seem to be increasingly aware of the very real possibility of running the claim in such a way that will lend itself to creating division between defending insurers and reinsurers. It has also been said that the influence of the younger generation on jury outcomes seems to have resulted in much larger awards than we were seeing 10 years ago. Large corporations and Fortune 1000 companies find themselves targeted for their deep pockets. Commentators have observed that this rise in anti-corporate sentiment dates back to the financial crisis. It is unfortunately evident that the general public places a low level of trust in insurance companies and financial services across all sectors. Widespread anger focused on large organisations has led to large corporate risks often paying significantly more than other risks. Often the first thing that happens in courtrooms is the plaintiff's attorney will ask, well, how much insurance does this entity have? Immediately, the tone is set. Liability insurance with coverage in the region of $1 billion is not unusual. So to conclude this whistle-stop tour of an admittedly vast subject, how can large corporations and their insurers focus on managing exposure? Ultimately, it seems the answer could lie in detailed and transparent data sharing. Complex and thorough information is required from clients to determine where key exposure risks lie. Liability insurance risks often need to be offset against other lines of business that they might not reinsure. Work needs to be done with clients to ensure that there is a detailed understanding of how much exposure they have and why it creates stress across the industry, including in reinsurance programs. There needs to be a better appreciation amongst large corporations of the motivation behind seeking detailed data and information in the broadest sense. It needs to be made clear that the goal is not to raise prices unnecessarily. The sharing of data, which in this digital age should be readily available, needs to be much more run-of-the-mill in order to turn the tide and level out pricing. The next talk in our series will be presented by another of Foyle's guest speakers, Salim Khalid of 1 Chancery Lane Chambers, who will be looking at cladding claims in the current climate, including a consideration of who is liable, arguments for those claiming and those defending cladding claims, what losses are recoverable, and the associated insurance-related issues. Thank you so much for listening.